Again, welcome. Our mission, our purpose in doing these Wednesday webinars all the way back to March and April of 2020 has been to share with different folks important topics, short topics. We're not here for hours. We're not diving into all the crazy details and nitty gritty, but to give you an overview of very important topics as far as estate planning, asset protection, elder care, and long-term care. And tonight we'll be focusing on estate taxes, all right? And how exactly there are ways that spouses can plan if something happens to the estate taxes as it's been discussed over the last year. Again, we'll get into it. If you have questions, please, in the Q&A box or in the chat, put your questions in there and I will answer all that I can once we're done. If you have friends or family that have missed this or you want them to catch it afterward, you can send them to our website, tullyelderlaw.com, and under videos and click on webinars, then there'll be all the webinars for the last year. Enter their email address just kind of as a login there, and they can watch it at that point, all right? That page has webinars going back, dealing with Medicaid work, healthcare advance directives, avoiding probate, powers of attorney, a lot of different 30, 45-minute webinars just to give you enough information to start thinking about what you can do as far as planning and protection for yourself and your family, okay? All right, so let's get started. And we do have a good turnout tonight, which is nice. So as we get into estate taxes, now you're here obviously because you're aware of what perhaps they are or the idea of planning. So let's start at the beginning. What exactly is estate planning? And I always like to start with the foundations because there's some folks that may not be familiar with it. The idea of estate planning often comes up, the idea of I need a will. I need to have a will in place for when I pass away. That is only a portion of estate planning. So point one is estate planning certainly includes inheritances. Where do your assets go when you pass away? But what people don't often realize, but it is probably more important, quite honestly, is incapacity planning. So estate planning not only includes where do my assets go when I pass away, but it's also who is going to help me if I become incapacitated or disabled while alive, before even passing away. Estate planning also includes asset protection, specifically in regard to long-term care. From our perspective, there are different types of asset protection or creditor protection that different estate planning firms focus on, but our perspective is going to be how do we protect our assets most of the time in dealing with the long-term care possibility as we get older. Now, today's focus is taxes. That is also a part of estate planning. There are numerous taxes out there. We all know that, especially in New York and on Long Island. But today we'll be focusing in and zeroing in on estate taxes. So for those of us that know what estate taxes are, I've heard of them before, it is simply a tax on your right to transfer property at your death. You have X amount of dollars when you pass away. If it is over a certain threshold, which I'll explain, you're going to get hit with taxes. You know, in New York, we have a New York estate tax and we have a federal estate tax. Other states do not have a state estate tax, just the federal one. So where you reside dictates the level of taxation that you're going to have. All right. Estate taxes are also called transfer taxes. Okay. It can deal with gifting the money during your lifetime or leaving it, bequeathing it, devising it to family at your death. So it's a transfer of the assets during life or at death. Now, not every single transfer is taxed. If you leave it to your children, yes, it's going to be taxed. But if you leave it to your spouse, then you have something else at play. And it's what's called the unlimited marital deduction. And what that is it's the ability to transfer literally an unlimited amount of assets to your spouse at any time, including at death, free from transfer taxes. So often when we're sitting with clients, we'll talk about money being transferred for different purposes between spouses. There's never a tax during life, and the unlimited marital deduction states that there will never be a tax at death. So you can have a person worth an extreme amount, let's say $100 million. Yes, they're over the estate tax threshold, but the reality is if they leave everything to their spouse, they will not be taxed one penny. Sounds great, perhaps though, but but it's not a good planning strategy per se, and that's what we're here to talk about tonight. All right. But again, knowing that we have the unlimited marital deduction is very favorable when it comes to inheritances and planning, so that you can provide for your spouse should something occur in the future. Now, to get into the estate tax portion, every estate tax, whether federal or state, has what's called an exemption amount. All right. It's also called a credit against the estate taxes. What that means is not every single dollar from dollar one is going to be taxed. There is a level of money, an amount of money that can always pass under the threshold amount without any estate taxation. And again, that's called the exemption amount. So that is literally the amount of assets that you can pass on to your heirs free of any estate taxes. All right. And I'm going to get into what they are for us here in New York and, of course, federally speaking. It's gone up throughout the years. For decades, I first started practicing in 1998, so a little over 23 years ago. And the exemption amount was about $675,000 on the federal level. That was not a lot of money. It has gone up gratefully, dramatically over the last 20 years, last 10 years, really. So that's been very favorable as far as that increasing. And also on the New York side. Many will argue that it hasn't gone up enough as far as an exemption amount. And many will argue that it's too high. And that's not the point of tonight. So New York, as I shared, in New York, we have two different estate taxes, both a New York estate tax, meaning any New York State residents upon their passing can get hit with a New York estate tax prior to the federal tax kicking in, okay? And as we've discussed, every estate tax has an exemption amount. So in New York, I'm going to say gratefully, it's been increased over the years. It is now an exemption amount in New York of $5.93 million. That means $5.93 million and under, no New York estate taxes whatsoever, all right? Because there's that exemption. But if you go over the $5.93 million, then yes, you're going to be paying estate taxes in New York. Now, you might be saying, boy, that's a high number. That doesn't apply to us, Brian. Well, listen, because there's potential changes on the federal side, and I'm going to get to those in a couple of minutes. And that's where it's going to scoop up, and if they do occur, and capture more people. So in New York, if you are, again, over the $5.93 million, there is a top tax rate at 16%. That, again, it's a high number, but it is not, in fact, a terrible, terrible number. It used to be much, much lower a number of years ago. So we're grateful it is what it is now. Now, when the governor increased the New York estate tax exemption up to the 5 million range, a lot of New Yorkers were very, very, very pleased. However, you don't get nothing for nothing here. The way the law was drafted was, yes, that amount passes estate tax free, but be careful, because you have what's called in New York a 5% cliff, okay? So 5.93 million, no problem, it's New York estate tax free. $6 million, no problem, New York estate tax free. As soon as, however, you hit 5% greater than the 5.93, this 6.2 million I have on the screen here, as soon as you hit 6,226,500, you are now 5% greater. In other words, you're at 105% of the New York State estate tax threshold. And as soon as you hit that, you lose all, from dollar one, you lose all estate tax exemption in New York State. Everything from dollar one is taxed, graduated levels up to 16%. So up to that $5-6 million number, you're fine. But again, this cliff is out there for a lot of folks, and they're not aware of it, all right? Even talking with some of their attorneys, of course, that don't do this type of work, they're not aware of it either. So if you have that estate, gross estate, perhaps taxable estate greater than a $6 million number in New York, then everything we're saying today 100% applies to you. Now, also very, very interesting in New York, it is what's called use it or lose it. Now, what that means is, and again, really the thrust of what we're talking about tonight, Use it or lose it means every individual has that $5.93 million exemption. And if you pass away and leave it all to your spouse, if you're married, remember there's that unlimited marital deduction. So if I've got $5.93 million in my name and my wife has $5 million in her name, and we don't, by the way, but if we did, then what would happen is my 593 would pass to her. And in essence, when that occurs, I have failed to use my New York State estate tax exemption. The way to use up the estate tax exemption in New York State is either leave the money to the children or leave the money to a trust. Okay? If I leave it to my spouse, I lose it. Use it or lose it. Very, very critical, just as important as that cliff part as far as New York State is concerned. Okay? So therefore, planning for what we're talking about tonight requires advanced planning. It requires you being proactive and implementing the strategies that we'll be talking about in a couple of slides in New York, okay? You certainly don't want to lose the opportunity to minimize taxes, all right? Now, federal taxes. And again, as I shared in the beginning, this is an overview of our current structure. You know all the tax laws and the Internal Revenue Code, thousands and thousands of pages. So my point today is to share with you how it can work in a nice general sense to get you thinking. Now, federally speaking, good news for a number of years is we've had a very, very high, again, according to most people, estate tax exemption amount of 11.7 million. And when I'm sitting in consultations with folks and they're like, all right, I've heard about estate taxes, and I'll be like, oh, well, the New York number is this 5.9. They're like, oh, great, I don't have to worry about it. And the federal over 11, they're like, wow, don't even have to think about estate taxes for most folks. But for those of you that are up there, once you're dealing with a federal estate, taxable estate greater than 11.7 million, you can be hitting a top tax rate of 40%. Significant numbers, all right? Think about it. You got a $15 million estate, and understand this. This includes everything. Your estate, your taxable estate includes everything you own, everything you have an interest in. Life insurance, death benefits, retirement accounts, real estate in other states. Everything gets added and grouped together in your taxable estate. And again, we're here talking about this because there are potential changes to this number, all right? Huge tax rate of 40%. Now, interestingly, and a good thing, is the federal estate tax exemption, not New York, but only the federal estate tax exemption is portable. Now, that is not something to be relied upon. That is an emergency crisis Band-Aid if you have to do it, all right? Because if we've learned anything throughout the years, laws change, tax laws change, exemption amounts change. So if you're relying on portability for your federal estate tax planning, I do think that's a mistake, and you should proactively undertake estate tax planning that we'll be talking about tonight at a minimum, all right? Now, what does portable mean? Well, remember I said in New York, it's use it or lose it. Portable means that I don't need to build an estate tax strategy into my estate tax plan, because if I pass away with, again, a huge number of, let's say, $8 million in my name, and my spouse also has $8 million, I don't have to set up a trust right then and there. My wife doesn't have to set up a trust right then and there. She can file an estate tax return, all right, after the fact, after the spouse has passed, and the unused exemption amount is then portable to the surviving spouse. Now the surviving spouse, just by filing the tax return and by checking the box, is going to have the over $23 million available. So federal taxation on the estate tax level is portable between spouses. Again, not the way you want to go, because it is unreliable, all right? And things change. That, again, is there as a crisis if there was no tax planning during life. And we've had estates where we've had to file that. I'll get into that in a little bit. Now, one last point, and a little bit of a kick in the pants, unfortunately, is this high number of 11.7 million is already slated to drop, all right? In January of 2026, that means we've got about 4 more years, it's being cut in half already. So even if you were relying on, oh, I've got 6-7 million and I've got an 11 million estate tax number, you always have to plan for flexibility. You always have to plan for options. You always have to plan. And if you just rely on the law as it stands today in regard to your planning, it can really be a wake-up call when the laws change, all right? It's not only about the White House, it's about Congress. It's not only about the White House and Congress, it's about your state legislature and governor as well. So those change over time, and therefore the laws change. The way this is slated to change is, again, 2026 cut in half from 11.7 to 5.4 million, okay? The indexed means it's indexed for inflation. It'll keep going up. For example, the New York number is indexed for inflation, and we're at 5.9. So when this happens in 26, we'll probably be around 6 million, okay, on both the state and federal side, all right? Again, good numbers, but you have to plan, okay? Now there are, since we've had a Biden White House and through the campaign trail, there was always discussion of changing the taxation structure in the country. They've been passing different legislation as far as infrastructure, et cetera. That has to get paid for somewhere. And the types of taxation changes that have been brought up, income tax changes, corporate and personal, capital gains changes, big deal. And this actually might be happening even before any estate tax issues are involved or passed. Capital gains, and that's not the point of tonight's talk, but to understand, we right now have something called a stepped up basis allowance, all right? And what that means is when we inherit assets from our parents, capital gains taxes disappear. So, and we do this with our asset protection trusts all the time. We want what's called estate tax inclusion so that we can obtain a step up in the tax basis when our children inherit from us. So for example, what the step up allows for is when my wife and I, years and years, Lord willing, pass away from now, years and years from now, our children will inherit our assets at fair market value, date of death, fair market value. That means any gain disappears, all right? Now, what is being discussed and actually may be happening sometime in the near future is changing from a step-up basis scenario to a carryover basis scenario. And what that means is, I'll give you an example. During lifetime right now, if my dad had, bought $100 worth of Apple stock 15 years ago, now let's say it's worth $1,000, more than that. And then he was to give that to me during life. I, as a donee, as a recipient of his lifetime gift, receive his basis of $100. So then when I sell it for 1,000 plus, then I am going to be paying a capital gains tax. However, if my dad passes on, years again down the road, please, I will be inheriting it at $1,000 value, fair market value, date of death. The capital gains disappear. So that's an example of carryover, which is a lifetime gift, versus step up, which is an estate inheritance amount. What the government is talking about is making this carryover happen at death as well. So when children inherit from their parents or beneficiaries inherit from those that are leaving them any type of assets, the reality is if they take in a carryover basis and receive the low basis, not the step up, when they sell the asset, they will be hit with a significant capital gains tax. They're talking about building in an exemption amount of $1,000 worth of gain or profit. I'm sorry, $1 million worth of gain or profit. But again, it's still going to be significant. All right. Now, the last tax that they've been talking about is changing the transfer taxes. And as I've shared, that is the gift taxes and the estate taxes. And I'll be the first to admit that seems to have taken a back seat, and hopefully we don't see the changes. But what I'm sharing with you tonight is in case we do, but also as a word to the wise, it's nice to have the type of flexible planning I'm going to be talking about shortly, because again, laws change. When you're talking about different governments and different agendas and different political perspectives, tax exemptions go up, tax exemptions go down. So what I'm sharing tonight is going to apply to those with somewhat taxable estates, all right? So if you're sitting at a $2-3 million number, then this is what's going to apply to you, okay? Now, the discussed transfer tax changes, just focus on the estate tax side, is you're looking at a $3.5 million exemption. Remember, federally, we're at 11.7. In January of 26, it's dropping down to the $5 or $6 million number. What's been floated out there is knocking that out altogether and going to $3.5 million. Again, we're hopeful it's not going to happen. It's kind of taken a back seat to the capital gains issue, but who's to say it's not going to come up again, all right? And I can almost guarantee you it will come up again. So if that were to happen, that is going to bring a tremendous amount of folks back into the estate tax planning world, because this includes life insurance, this includes retirement plans, okay? If this were to happen, again, it's going to be significant. Moreover, not just dropping the estate tax exemption, but increasing the estate tax rates. I said before, federally, we're looking at 40%. They're talking about jumping the federal estate taxes 45% up to 65%. Now, of course, those are the tens and hundreds of millions of dollars estates. So that's not going to be your Tom, Dick, and Harry, but those are big numbers, folks. So we got to keep an eye on what's happening with the estate taxes. Bottom line, what do we do? And you know what I'm going to say? I'm going to say plan. Take advantage of where we are right now. Undertake the planning. I will say, as an aside, there's been a significant influx of clients with multi-million-dollar estates. I'm talking 8, 10, 12, and up millions of dollars. Why? Because you're dealing right now with this high $11.7 million federal estate tax exemption. That means you can give away up to that amount without paying any gift taxes, or you can die with that amount and not pay any estate taxes. We may never see the $11.7 million again. So those with high net worth estates are actually taking advantage this year. You got 6 months to go, taking advantage of this very high exemption and establishing significant, important estate tax plans, taking advantage of the high exemption amounts. There's different types of what's called discount valuation planning. There's different types of business entities that can be utilized in owning assets and transferring assets. There are certainly things that can be done if you are in that high net worth category, all right? So if you are, please, word to the wise, feel free to give us a call and we'll be able to help and get that plan in place for you. So planning, what do we do? What do we do? I'm going to give you 2 examples, okay? A simple example where there's no planning done, and then a better example when there is planning done, the type of planning we'll be talking about. These are simplified, folks, all right? So if you've ever sat in a consultation with me, my goal is to share as if we're sitting around a kitchen table. I'm not here to drill down to the penny and overwhelm you with all the details. I want you to get the concepts, okay? So here first is our simplified example. So we have a husband and wife, Mike and Carol, all right? And whoever can think of who I'm talking about there, put it in the chat box. So maybe you'll win the raffle. Anyway, Mike and Carol, married. Let's say they have assets of $5 million and they are entirely joint. Very, very common. If you think about your own assets with your spouse right now, house, probably joint, bank accounts, joint, investments, joint, retirement accounts, you leave your spouse as the beneficiary, life insurance, you name your spouse as beneficiary. Everything goes to each other, okay? Very, very common until we start talking about estate taxes. So in my scenarios, you have to knock somebody off. So forgive me, I knock off Mike. So let's say Mike has passed away. Now Carol is sitting on a $5 million estate in her name alone. If the estate tax threshold has dropped to $3.5 million, all right, remember, on the New York side, it's use it or lose it. They didn't do anything. So now you've got this number out there for Carol. On the federal side, let's assume that she did not take advantage of portability, all right? She just didn't do any tax planning, post-mortem tax planning. So now we have Carol sitting on a $5 million estate when the federal estate tax exemption perhaps is at $3.5 million. We spoke about a 40% tax. That means Carol's kids, the 6 of them, are now paying $600,000 in estate taxes. Big number, guys. All right, that's a lot of money. It's $100,000 per kid. So that wasn't the most prudent or wise way to plan their estates. Okay, so let me give you an example of planning utilizing the marital estate tax strategy called a disclaimer credit shelter trust. This tool, this is really the foundation when it comes to marital estate tax planning. It's step one, the vast majority of the time. And on top of this planning, you layer in other strategies, you layer in other types of trusts. It's where you start, okay? So this type of planning can be anywhere from anywhere $2 million and up. Again, planning for the future because you don't know what you're going to be looking at down the road. Some folks, we talk about it at 2 million and up, but they may not want to do it because the exemptions are as high as they are. So most folks in the $3 to $4 and $1 million range and up are the ones that we're really recommending this type of planning. Now, this type of strategy, in order to work, again, disclaimer, credit, shelter, trust, requires 3 things. The strategy itself must be built into the plan while you're alive, okay? You're not relying on that portability. It's not something you're doing post-mortem. It needs to be done proactively and correctly in your plan while you're alive. Secondly, there needs to be an equalization of the assets between the spouses. All right, this is often not done, but it is probably the most important. I'll give you an example. Mike and Carol, $5 million. If Mike had all the money, oh, let's go better. Let's say Carol had all the money. All right, Carol worked hard. Carol has $5 million in her name. Mike has a bank account. Mike has a small IRA. If Mike passes away, there's not much money in his estate to utilize the exemption. So he didn't use it, therefore he's going to lose it ultimately. And if he passes first, Carol's still sitting there with $5 million, which means $600,000 in taxes, right? So if we can equalize the estates as much as possible, does not have to be exactly 50% equal, but if you even go 3 million, 2 million, at least you're giving yourself a chance to shelter some estate taxes, okay? So equalization between the spouses is very important. If most of the value, most of the wealth is in retirement accounts, you're not equalizing those. If it's in a certain business or stock options, et cetera, you're not going to be able to transfer those between spouses. So you have to look for assets that can be used to equalize. The third aspect of the disclaimer credit shelter trust, in order for it to be fully utilized, is it has to be funded at death. Remember, it has to be, the strategy's got to be in the plan, but it's not funded until after death. Okay, now let me explain how that goes. So we got Mike again. And again, we're still sitting with the $3.5 million federal estate tax amount. Equalization, as I said, we're looking at Mike, again, round numbers, folks. Mike about 2.5 million, Carol at 2.5 million. Sometimes the real estate, for example, if Carol has 4 million in her name and Mike has 1 million in his name, then sometimes we give the entire house to Mike. We can't give retirement accounts. We can't give business assets usually. So you use whatever assets you can to equalize. So again, for our example, for the concept only, $2.5 million each, okay? Now, again, Mike's gone, all right? That's just how we're gonna do it. What that does is it brings Carol up to $5 million, right? So she's gonna be inheriting that from him. However, their planning includes disclaimer credit shelter trusts, all right? So what that means is Mike's will or trust and Carol's will or trust actually says, I give everything to my spouse. That's what spouses want. So this estate tax strategy does not remove that possibility. So you're literally creating a plan where everything can be left, will be left to the surviving spouse, but you have the ability as the surviving spouse to actually disclaim, okay? So that's why it's called a disclaimer credit shelter trust. So Mike's will or trust says, I leave everything I've got to Carol. Carol then has a period of time all right, after Mike's passing, to actually sit with tax advisors, sit with CPAs, sit with us, sit with whomever she'd want to actually to decide whether she should inherit it all. What are the estate tax structures at the time? What are the exemption amounts? What are her living expenses? What are her debts? What do her children need as far as living goes? Should she take it all, or should she disclaim and say, no, thank you. I don't want this $2.5 million. That's a legal process. It's called a qualified disclaimer, okay? And it's often done when we have taxable estates. So if she were, again, in our simple concept example, to disclaim, that's that little X you see there. See the arrows heading over to her. She says, no, I'm going to disclaim. What's going to happen is that $2.5 million does not, from Mike, doesn't go to her. Rather, it kind of bounces off of her and goes into this DCST. What's that? That is the disclaimer credit shelter trust that we're talking about, okay? So again, to recap, Mike's will or trust leaves everything to Carol and vice versa. Mike passes first. Everything's on its way to Carol. Carol can stop it and say, I don't want all of it, or I don't want a portion of it. And she has to file a disclaimer. The attorneys have to prepare that. It gets filed with court. And then that money is funneled into the disclaimer credit shelter trust. Now, all that is, guys, just reading upwards, right? T, it's a trust that shelters C, the credit, and it's done via the disclaimer. So this is a trust that shelters the credit, that exemption amount, by virtue of a disclaimer. And there's your other $2.5 million, okay? Now, great news is Carol still lives off of that money, okay? This is not money she loses. She still has full access, and I'll talk about that a little more on the next slide. Very, very important point. I keep talking about this disclaimer. I put it in red. 9 months from the date of death is the deadline, if you will, for the qualified disclaimer to be filed in order for it to be effective. Don't do it at 10 months, it won't work. You want to, of course, you have to deal with the family and the time it takes to heal and to grieve. But as you start coming out of that, you got to start dealing with the finances. And again, talk with the CPA, talk with the attorney, and decide whether a disclaimer is appropriate. It has to be filed with the courts within 9 months of the first date of death, okay? Now, again, if you've got questions about that, let me know. So this disclaimer credit shelter trust, okay? A real nutshell type of explanation for you. It exists for the lifetime of the surviving spouse, all right? Now, that spouse can be the co-trustee. Every trust, and we talk about this in other webinars, has to have a trustee. And in order for this credit shelter trust to exist, it has to have a trustee as well. Typically, it is a child, a trusted, mature, responsible child, and the surviving spouse as co-trustees, okay? That way, the surviving spouse still has access, still has control. Now, what does she or he have access to? To the principal and the income. Now, remember, Carol, in our example, is still sitting there with $2.5 million. That's hers to do whatever she wants with. But she now has access to the $2.5 million that is in this credit shelter trust for the rest of her life. So she's able to be able to pay for other things, college for the kids. Money can even be distributed to the children, okay? Now, at the death of the second spouse, when Carol ultimately passes down the road, all $5 million will pass to the children, okay? Her $2.5 million and the $2.5 million from the disclaimer credit shelter trust will go to the children, whatever obviously hasn't been used. This one strategy alone, again, the foundation of marital estate tax planning, just saved Mike and Carol and the kids $600,000, all right? Now, of course, in order to see that benefit, the federal estate tax threshold has to drop. But even if it doesn't drop, what's the harm of having this type of a trust within your plan? Again, everything goes to the surviving spouse. All it does is give you flexibility and another bite at the apple, all right? So to me, this is a very valid, a very important aspect of planning, especially with the potential of estate tax thresholds and exemptions dropping. And as people keep working and accumulating assets, their net worth is increasing. So something to consider. There's two ways to do this, two ways to implement this, okay? The first is through a will. It's what we call a probate estate plan, all right? The probate estate plan is going to rely on a last will and testament to contain your dispositive provisions. It's going to contain your marital estate tax strategy. Your disclaimer credit shelter trust is built into your will. Now, it also includes what we call a durable modified power of attorney, maybe the most important document out there. You do not want a power of attorney from LegalZoom. You do not want a power of attorney from your real estate attorney. You want a power of attorney from an estate planner, from an elder law attorney that's going to build in all the right tax provisions, planning provisions, asset protection, income protection provisions, okay? Very, very important document. If there is no power of attorney in place, or if it is not sufficient, meaning it doesn't have the right language, the family is going to be forced into a guardianship. And that is something you don't want to put your family through. The probate plan also includes a healthcare proxy for healthcare decision-making and a living will. That's the end of life statement that says that I do not wish to receive any artificial treatments to keep me alive, all right? Now, back to the will. This is the probate plan. If you're relying on your will to distribute your assets and to put into effect your credit shelter planning, it must go through probate first. Probate is something that should be avoided. There's time delays, there's court fees, there's legal fees. It is completely public. Everything that you're writing in your petition, your family, your children's names, children's assets, approximate assets going through the will, all there in public. And I just don't like our clients having that type of information out there in this day and age, okay? So we prefer our clients to implement what's called a probate avoidance estate plan, all right? Now this probate avoidance estate plan, you're of course gonna have a last will and testament. You always have to have one. It's gonna have your power of attorney. It's gonna have the healthcare proxy, a living will, but most importantly, it's going to have the foundation of a revocable living trust. This is not an irrevocable asset protection trust. This is an estate planning tool called a revocable living trust. And we build in the estate tax strategy called the disclaimer credit shelter trust. Full control, full access. The money is for you. It is a management vehicle and it is a probate avoidance vehicle. Save the time, save the money, stay out of court, okay? Now, the revocable trust, just to give you a couple bullet points, I took this slide from another presentation, but it's a good one. So the revocable trust avoids probate, it maintains privacy, it saves time, it's faster access and inheritance, it minimizes litigation by heirs, because if you have to go through probate with your will, if you disinherited a child, or if you can't locate a child, or if you give them a different percentage, they don't have to sign off. They can drag things on for years. So by staying out of the courts, you're minimizing that. It avoids ancillary probate in other states. Everywhere you have a home or vacation property, you have to do a probate, not if you have a revocable trust. It saves on the probate legal fees, the court fees, and even bonding. We've got a client who was in here last month. He just wrote a $9,000 check for a bond to be an executor. All right, so you got to be careful. Probate's expensive. You're not required to locate missing heirs. The court is not involved. If you have a minor child in probate, they're appointing a guardian ad litem, all right? And that's going to take time and money to make sure that that guardian ad litem is satisfied that the minor child is being cared for financially through the estate plan. It's easier to use a revocable trust when you're dealing with financial institutions than the power of attorney, and it minimizes what's called estate recovery. That is that's a Medicaid concern for those families that are receiving long-term care Medicaid, okay? So tonight, and we're running out of time, so I want to get to some questions. We spoke about estate taxes. We spoke about the unlimited marital deduction. We spoke about the federal exemption, the state exemption. We spoke about examples of not having any planning in place and what the taxes can be, as well as how to implement really the foundation of marital estate tax planning with the disclaimer credit shelter trust, okay? Keep your eye on the estate taxes. We'll keep you posted. You can sign up for our newsletters or our Facebook page. We'll keep posting content on all of those things. If you have any questions, or if we can help you, if you wish to sit down and review the need for the estate tax planning, or even if you're aging, the Medicaid work, the regular estate planning for younger folks, asset protection planning, if you're 65 and above, you should be working on protecting your assets for the future. give us a call. I'll be happy to sit down with you, review your current scenario, make our recommendations, okay? A real pleasure to be with you again tonight. Let me see if we have any questions. All right. All right. Okay. All right. Good thing. All right. We don't have any specific question. So people were saying you couldn't see my PowerPoint. Isn't that strange? So if you folks didn't see my PowerPoint, we had a problem this whole time. Hopefully that didn't happen. And that was only a select few, I hope. No specific questions. So again, thank you for tonight. And we will see you again next week. Bye-bye. Where is my button here?